Hi everyone, I'm Michael Redden, and once again, welcome back to Wealth Preservation TV. Today we're going to talk about a particular topic. It is your first line of defense. It is your state level exemptions. These are basically things at law that no creditor can take from you. These will be honored in bankruptcy court if you so choose instead of the federal exemptions, but any creditor who wants to come after you cannot take these things. It's just prohibited by law. Now, each state has a different set of them. Some states, like Florida, have some very generous ones, especially in the homestead. And some states, like Minnesota, are a little different. See, Minnesota has a state constitutional provision that prevents the legislature from exempting an unreasonable amount from judgment. Your state's going to be all over the place in here, okay? And if you have assets in different states, then there's going to be a question about which one of those exemptions apply. So you need to really know how those things are going. But since I'm an attorney in Minnesota, and Minnesota is one of the ones who has a lot less protection than other states, we're going to give you some examples of some of these things. A lot of things are unlimited, like your clothes and things like that. But one that I always like to point out is your wedding ring. How many of you have a wedding ring, or your spouse has a wedding ring that is worth over $2,800? In Minnesota, if it's worth more than $2,800, then they can take it. They can give you that $2,800 in change. It's not 28 exactly, 28 and a little bit change after that the exemption amount is, that it adjusts for inflation. But they can give you that check and take that ring. Another one of these issues is your car. In Minnesota, your exemption is only $4,600. Think about that. Do you have more than $4,600 of equity in your car, even if you've got just one? A lot of people have that misconception that you have to have two cars, they can take one, but they can't take my one car away from me. Yes, they can. Back when I used to be a creditor's attorney and do this kind of thing and go take people's stuff, I had a client who had a debtor, and this debtor didn't have a lot of assets, but I noticed that they drove a BMW. Well, I subpoenaed the creditor and found out the exact month it was going to be paid off. And the sheriff showed up that exact same month, gave them a check for $4,600, and we took that $20,000 vehicle. They could show up at the auction just like anybody else and bid it up, but we got it and we sold it, and my client actually got more than their $4,600 back because the owner never showed up. And it's not like on a mortgage. If at that auction they pay 20 grand for it, you don't get the difference. The creditor gets it all. The other piece of some of these things is life insurance. A lot of higher net worth people have life insurance for maybe their retirement plan. Maybe it's a part of some key man things. Maybe you're on a split dollar. Maybe you've got life insurance and you're keeping it with cash value as a part of your long-term care insurance strategy. Well, if it's got a cash value above $9,200 in Minnesota, it can be taken. I can go right in there as a creditor and say, hey, life insurance company, send me a check for everything but $9,200. That can blow up your plan. That can make you lose a lot. And that's something you want to know that's not protected, and do some other strategies to protect. Even life insurance proceeds aren't given much favorable treatment in Minnesota. If we're a part of a buy-sell or something like that, and I'm not married to the person and I get the death benefit, none of it's protected. If I leave that death benefit to a kid and he's got creditor problems, none of it's protected. Leave it to an aunt, a friend, none of it's protected. If I leave it to a spouse, $46,000 is protected. If you got a $2 million policy and all she's got protected is $46,000, there might be a problem. So you might need to go and do some other strategies to help protect that. The other big one that people don't realize is retirement accounts. Some of these accounts are ERISA covered. ERISA is a federal law, and when it's ERISA covered, you can't get in there unless you have one of those for federal permissible means, which most creditors are not going to have. But some things aren't covered, like IRAs, general annuities. Those things are not covered, and those kind of things in the aggregate can only protect $69,000. So if I've got $60,000 in an IRA and $100,000 in the annuity, I get to pick my poison. I can leave $9,000 in that annuity. Now you've got your $69,000, and I've taken it all. Those are the kind of things that you need to look out for with your exemptions. Some of these are great. Some of these you want to leverage and keep up with that. And those are the kind of things you want to look out for. So keep those in mind. Know your exemptions. Know the exemptions in every state that you own property in, and speak to an experienced asset protection attorney so that they can help you make the most of those and protect those when the exemptions are not enough. If you want to make a consultation with me, then click below and schedule one, and I'll be glad to talk to you.